Morning, everyone. So, hello and welcome to the second of our webinars for employers. I'm Angie Crush. I'm a partner in the employment department here at Thomas Mansfield. And today I'm joined by my colleagues, Jonathan Mansfield and Meredith Hurst.
Hello.
Now, many of you will know who we are, may already be our clients, but for those who aren't, I'll quickly introduce the firm. So Thomas Mansfield specialises in employment, family and private client law. The employment law team work with HR managers and also with business owners who don't have an HR function. Today, we'll be discussing redundancy and restructure. We recognise that this COVID pandemic is going to leave employers with some tough decisions to make in this area in all likelihood. And we'll look at alternatives to redundancy as well. Particularly, Meredith will look at changes to terms and conditions, as well as the actual meaning of redundancy, and then focus on the more practical side of consultation, both individual consultation and collective consultation. Now, while we do have areas and we've got a lot of material to try and get through to make sure that you've got the bones on this subject, we do want it to be interactive. So if you have any questions, please do ask them. Now, you can ask questions by writing them in the chat box, which should appear on the right-hand side of your screen. So if you pop the questions in there, I'll try and monitor it throughout the webinar and try and get some of those questions answered. If we don't have time to answer all of them, we'll try and follow up afterwards with those specific questions. So Meredith, let's start by asking you to have a look at something that most employers probably are going to consider before they start the redundancy process. And that's the question of, can they change their employees' terms and conditions, which may of course lead to a reduction in the numbers of redundancies they need to make, or even potentially avoid redundancy altogether if they can change the terms and conditions to suit their needs going forward. So how can they do this?
Well, if an employer wants to reduce, for example, hours of work or pay, then they have four principal options. The first is to look at the express or written terms of the contract. The second is to try to agree the changes, which tends to be the preferable way of doing things. The third and least perhaps beneficial is to impose the changes and hope for the best. And the third is to terminate the contracts and re-engage. So looking at the contractual variation piece, we're often asked, well, can we do this? A contract of employment will contain either specific flexibility clauses, the most common one being a mobility clause, or there will be a general variation provision. In relation to specific flexibility clauses, I'm not saying necessarily forget it, but rarely will you see a clause that allows you to reduce pay, for example. The power to reduce pay needs to be expressly and clearly set out in the term. And such a clause is not something that we see very often. Remember also that if you are invoking an express contractual term, then you need to exercise it in a way which doesn't damage trust and confidence. So, for example, if you're withdrawing an overtime bonus or some other form of benefit, then it's sensible to put in some form of transitional arrangement so that the employees who've entered into financial commitments are not subjected to a detriment in any way. In relation to general terms, what you're likely to see is a clause that says something like, and we see this quite a lot towards the end of the contract, we reserve the rights to vary this contract from time to time. Now, practically speaking, that won't allow the employer to really do a lot more than, let's say, change a healthcare provider. If you've already got a healthcare provider and you're introducing a new healthcare provider who are providing the same benefits.
And what if you don't have a contractual right and can't agree the change? What happens then for employers?
If you can't agree and you don't have the contractual right, then you're left really with either abandoning the changes that you want to make, which isn't going to be particularly attractive, or you impose the changes and take a punt and hope for the best. But if you impose changes, then that is a breach of contract. What the employee does next, however, is key. If the employee clearly objects, and they would have to object vociferously and make it very clear in writing that they object, at least you know where you stand, but it may mean that you face litigation. Alternatively, the employee may carry on working. They may not do anything, or they may not object vociferously. That could indicate acceptance to the terms based on inaction. Now, there are two cases that I looked at, one where an employer had introduced a 5% pay cut. Employees didn't take any action or object for 6 months, and they were found to have accepted the change. There was another case involving Nottinghamshire City Council that introduced a pay freeze for 2 years. And when the council elected to extend the pay freeze for a second time, the employees at that point brought unlawful deduction from wages claims, and they were found not to have accepted the change. The facts of that case were quite specific, however. They were unionised, and the union had lodged a complaint in the early stages. It just goes to show that every case depends on its own facts.
Yeah, and you can't always assume that just because you haven't heard anything back from the employers that you're absolutely safe. And what can the employees do in these circumstances if they don't agree with the change their employer's proposing?
Well, if it's a term that affects their pay, then they can, what we call in legal terms, stand and sue. What that means is they can continue working under sufferance, and they can bring an unlawful deduction from wages claim. There are a couple of unusual cases where employees have said that they will continue to work under sufferance, but then have refused to do any work at all and continue to be paid. And the employer was, in those circumstances, legitimately able to dismiss for gross misconduct. But that would be unusual, and I wouldn't recommend that you rely upon that. The employee can resign and claim constructive dismissal, which may be successful, assuming that you have acted without reasonable and proper cause in implementing the changes. So given the uncertainty of imposing changes, it's not really the most attractive option, because you're really reliant on employee apathy and hoping that they don't do anything about it.
And we often get asked about sort of this idea of termination and re-engagement on new terms, where you terminate one contract on certain terms and immediately re-engage the workforce on another contract. Is that possible, and how do employers go about doing that?
Yes, it is possible. It gives you a more definitive position, because at least you know where you are. But of course, there is a risk that employees won't accept the new detrimental terms. And that's why it's so important to establish that you have a sound business reason if you want to advance a successful sum of the substantial reason defence. And a sound business reason is a reason that the employer genuinely believes is sound. It's not something that the employment tribunal has to necessarily accept is sound, because the employment tribunal cannot substitute its views for those of the employer. A sound business reason would be, for example, if you don't implement changes, then the business will come to a standstill. But having said that, there's no need for an employer to prove that reorganisation is crucial to the survival of the business. The scales tend to come down on the side of the employer in these cases. But, and it's a fairly big but, the employer must provide evidence to demonstrate the business reasons for making the dismissals and re-engaging, such as evidence as to whether the business is making a profit or loss. It will, however, be sufficient for the employer to demonstrate that it, as I say, genuinely believed the implementation of dismissals and re-engagement on new terms would bring about a reduction in costs. So the employer has to provide some evidence. They can't just advance an argument based on a hunch, or, as in one case, an edict from on high that cost savings were required, without advancing some form of evidence to support the argument.
I mean, I had a case where a company supplied certain services to airlines, and the airline had a change in their flight schedule, which meant that all of the shift patterns of their employees had to change to fit the new airline schedule. And that was a genuine reason, that was a fair reason, and they were sort of legitimate in terminating the old terms and re-engaging on new terms, even though they weren't as attractive. That's an example where there's nothing the employer can do about it. They really do need to go ahead and make this change. Now, just before we sort of move on to the redundancy side of things, on the right-hand side of your screens, you should see a poll. So I just thought it would be interesting to find out from anyone viewing how many of you actually think that making changes to your employees' terms and conditions might mean that you can avoid the need to make redundancies, or at least reduce the need to make redundancies. So if I can ask anyone to answer that poll, just click on the yes or no button, and then I'll wait a few minutes or few seconds and just see, whether it seems that actually that using that mechanism might enable sort of jobs to be saved with employers. And I don't think everyone can see the poll results, but I think people are still answering, but it's a pretty high majority. So about 70%, 66% are saying yes. If they were able to make changes to employees' terms and conditions, it could avoid the need for them to make redundancies. So that's pretty interesting. Yeah, it's ended up now, I think most people have pressed their button, sort of 65%, 35%. So I'll end that poll, but that's interesting that actually, if workforces and the employers can work together, perhaps jobs can be saved in all of this. So, Jonathan, we've been dealing with an alternative that most employers are going to want to look at, it seems, alternative to the dreaded R word. But the reality is that it's likely that some redundancies are still going to have to be made, and they're likely to be widespread. So can you just remind us at this stage what the word redundancy means?
Well, I guess the broad idea of redundancy is straightforward. We use it to describe a situation in which an employer decides to reduce the number of its employees, either within the business as a whole or particular site, a particular business unit or function, or a job role. But the precise statutory definition is quite important because it can influence whether a redundancy payment has to be paid, or indeed if it's used for a defence in an unfair dismissal claim. So it is important, and it's confused somewhat also by the fact that the definition when it comes to redundancy situations is actually different, and we'll come to that a bit later. But for redundancy pay and unfair dismissal purposes, we're looking at three basic scenarios where there is a business closure, a change of location, or reduced requirements for employees to do work of a particular kind. And
I think the first two tend to be easier cases to deal with. If a business is closing, clearly there's going to be a redundancy situation. And it's very often that last one, that reduced requirements for employees with work of a particular kind. So you've talked about this requirement for a reduction. How would an employment tribunal decide if that were actually the case, that an employer had reduced requirements for work of a particular kind?
Well, the employment tribunal recognises that it's really a commercial judgment for the employer, and the only thing that they would have, only situation they'd intervene is if they thought it wasn't genuinely the reason at all. They won't really look at whether it's a good reason. It could even be a daft reason. A case law example is Newcastle University had a course which was very well subscribed. So on the surface, it didn't look as if there was a reduced need, but they decided for commercial reasons that it wasn't viable, and the tribunal accepted that.
Mm. I think a key focus often is about whether there is a reduction in work of a particular kind. And employers have to focus on that when they're looking at the requirements and whether there is a redundancy situation. But what does that actually mean?
Well, the thing that the tribunal would look at in that case is the tasks and the skills. If there's a reduction in need for the particular task or the particular skills, they wouldn't look at the contract of employment, for example. At a case law, there's an example involving a Mr. Lamb. There were two corporate finance managers. One of them concentrated on mergers and acquisitions, and one of them concentrated on disposals. But in that case, it was found that there was a redundancy situation when there was a reduced need for the disposal side of the work. So coming back to this thing, it was the skills and the task were the crucial determinant. And there was a redundancy situation with two people in very similar roles.
And I think something that often can confuse employers is this crossover with restructure, because of course redundancy and restructure, they fall under separate parts of the Employment Rights Act in terms of fair reasons to terminate someone's employment. And sometimes it will satisfy both tests. You might have the same amount of work, but an employer decides that they want fewer people to pick up more work, and that then satisfies the test for both restructure as well as redundancy, because there are fewer people required. I think we're going to move on now to look at the more practical side of redundancy and consultation, and in particular at this stage, individual consultation. But again, just before doing that, and this is the last of the polls that I'm going to ask, but just to check that this is all relevant to everyone. I've put a poll: are you planning on making redundancies within the next 3, 6, or 12 months? Just to see how many employers out there feel it's going to be inevitable that they're going to have to go down this route with at least some of the workforce. So everyone's just answering that now, thanks. And I'll give it a few seconds just to enable everyone to click their buttons. It's changing around. I think the longer term 12 months isn't looking as popular an option as the sort of definitely the short term. So looking at the poll results, we've got sort of 48% of people saying yes, they're planning on redundancies within the next 3 months, 35% of people within 6 months, and the rest within 12 months. So, I mean, it's, we're definitely on topic here, and it's definitely something that people need to know about. So for everyone who, are planning on some redundancies, get your notebooks out, because Meredith's now going to have a look at what would an ideal redundancy process look like. Meredith, can you sort of give us an overview of the steps in this?
Yeah, well, I'm sure a lot of people who've logged in today will know some of the basics, but I'm just going to run through those anyway, just as an overview. I think some initial points to remember is that only employees with 2 years service can bring claims of unfair dismissal, and only employees with 2 years service have the right to claim a statutory redundancy payment. And that can be relevant and important when deciding who you're going to dismiss as redundant. You may approach those with fewer than 2 years service to start with. It can also be relevant to collective consultation when deciding whether you have 20 or more employees. There is no mandatory statutory procedure, interestingly, when you're looking at individual redundancy, but it is important to look to see whether you have any contractual policies, which quite often will detail how much people are owed, and that can be quite common in educational settings and the public sector settings as well. But employers must in any event follow a fair procedure. And a redundancy dismissal will inevitably be unfair unless an employer warns and consults with either representatives about the proposed redundancy or the individuals. A failure to consult will be fatal to a fair dismissal. You should adopt a fair basis of selection. I'm sure a lot of you know this already, but we'll look at some of the pitfalls there. And you must identify before you do that an appropriate pool of individuals, and that'll be the employees that you're looking to dismiss as redundant, either because you perhaps lost a major client or you have a reduced requirement for that work. And finally, you must consider suitable alternative employment, although I appreciate many employers won't have suitable alternative employment in the current climate.
And so the actual purpose of consultation, what are the key points of the consultation process?
Consultation is really designed to allow employees to have their say. I'm sure we know that, but it's important to remember that it should never be presented as a fait accompli. So you're telling the employees about the redundancy at an early stage, or the possibility of redundancy at an early stage. It's to allow the employee to understand in greater detail the reasons for the proposals and their proposed selection, and to question the assessment criteria you use. And that's another thing that I think is sometimes missed. Ideally, you should consult with employees about the proposed assessment criteria and the pool before you get into the selection. And it's also about how to avoid redundancies if possible. So having an open mind to any comments that an employee may have. Now, obviously, there's less room for discussion where you're closing a site down or where there's a significant geographical relocation. So, for example, a client that I acted for was closing in Hayes and reopening in Skelmersdale. The vast majority of the employees weren't able to move that distance. And you might say, was consultation necessary? Well, it's always important to consult anyway from an industrial relations point of view. But of course, the more controversial the situation, so if you're reducing 2 roles down to 1, for example, the more that will inform the extent and quality of the consultation required. The key components for fair consultation are, as I say, consultation when the proposals are still at a formative stage, so not when they are already a fait accompli, provision of adequate information to enable the employees to respond, provision of adequate time in which the employees can consider their position, and conscientious consideration of the response to the consultation. And another question we sometimes get asked is about the length of consultation. Now, of course, when you're dealing with individual redundancies, there is no mandatory procedure, as I say, so there's no set time during which consultation must take place. There are no prescribed periods. Having said that, the shorter the period, the more likely it is that the quality and the quality of the consultation will be called into question by employees and employment tribunals.
Mm. And it's the ideal scenario for employers when they are making redundancies is that they have someone in a unique role, and it makes it that much easier because they don't then have a pool of people to score from. But very often that's not the case, and you will be looking at pools of people. So what are the issues an employer needs to consider when deciding upon pools for selection?
Well, first of all, you're looking at the types of employees that you're looking to lose through redundancy, or the work of a particular hand that's disappearing. And you may say that's obvious. So, 10 employment lawyers are being reduced down to 5 employment lawyers. You know that the pool is the employment lawyers. But it's not always that obvious. And one issue that we see is where employees particularly will argue that their roles are interchangeable with someone else. Normally, it's in the employer's interest to keep the pool as narrow as possible. On the other hand, for employees, it's in their interest to keep the pool as wide as possible because it means potentially their jobs are saved. It's fair to say, and again, the scales come down in favour of the employer here, that employers have a fairly wide discretion over their choice of pool. But it is more complicated where employees are multi-skilled and do different types of work, or can be required to do so under their contracts. So the following consideration should be borne in mind when looking at a pool. Where an employee has previously done other work, other than the kind of work disappearing, this should alert the employer to perhaps broadening the pool and looking at interchangeable roles. Where the work is low skilled, however, we're talking about perhaps production line scenario, the skills are more likely to be regarded as interchangeable, and so you might include a wider scope within the workforce. But notwithstanding this, the law tells us that tribunals will rarely sort of weigh in and criticise an employer's choice of pool, because they're not there as arbiters of how that business should operate. And it's for the employer to confine the pool to those doing the same or similar type of work. That can be legitimate. I've seen a couple of questions come in.
Yeah, we've got a question from someone about whether last in, first out doesn't necessarily apply when retaining a recent starter who might be more beneficial for the company than one who's worked longer. And if the longer server is older, does ability rise above this? And I've got sort of quite a good example of this actually, and some of it goes to the weighting of the criteria, which, I mean, you're going to come on to selection criteria next, but for example, I had a situation where a company had, I think they had like 4 IT people, and one of them was relatively new and inexperienced in comparison to the others in many, many areas. But what this new person did have was particular specialist skills in relation to social media marketing. And that was seen to be the future of the business in terms of their marketing strategy. So for the employer, although that person couldn't necessarily do a lot of the stuff the other three could do, that skill was very valuable to them. And therefore, when they had a redundancy situation, they weighted that skill above the other skills. And in that scenario, then yes, the actual skill and the need for that skill for the business going forward outweighs who's been there the longest, which isn't generally the best criteria to decide on anymore.
Yeah, and I think it's a question of mixed criteria. LIFO, or last in first out, was traditionally used, but I think it's fallen out of favour, particularly as a sole criterion. As Andrew said, if you can look at skills and ability, which is quite legitimate, then a mixed set of criteria can be legitimate. And again, the tribunal won't really weigh in and criticise the criteria, provided there's an objective approach to it insofar as it's possible.
And that leads nicely onto what are the sort of issues with selection criteria, and are there selection criteria that employers should avoid? Yeah.
So, I mean, ideally, you would avoid subjective criteria. Things that are in favour of things like performance and ability. Well, I'll accept that can have an element of subjectivity there as well. Length of service, we've just discussed. Attendance records, disciplinary records, and that sort of thing. Purely subjective criteria are out of favour, not least because it means that personal animosity or partiality can come into play. But you will get away with a mix of subjective and objective. But I'll give you some examples of criteria that tribunals have found to be unfair. And they include an employee who, in the opinion of the manager concerned, would keep the company viable. I think the problem there was that it was down to one individual manager's view. Employees who are best suited to the needs of the business. That's fairly ambiguous and vague. And attitude has been described as, in one case, an undesirable criterion, as being too vague. That's not to say that subjective criteria are always unfair. Employee trajectory and future potential has been found to be a fair subjective criterion. And it can often come down to how the criteria are applied. And what we would advise is to have more than one person scoring individuals. And this can be relevant if you're using performance appraisals to inform performance and ability as one of your criteria. Because the problems with performance appraisals is that they may not have been used uniformly. They may have been approached differently by different people. And therefore, scoring should be undertaken by more than one person if possible. And I've got a specific case example here where a lady was, and you may say this was heavily subjective, but she was required to carry out a role play exercise in front of a panel. This was part of the selection criteria. And on the panel was somebody against whom she'd raised a complaint of discrimination. And the tribunal found that I wouldn't say they turned a blind eye to it, but they were prepared to accept that the presence of other people on the panel neutralised any suggestion of partiality. Looking at other things like attendance records, it's important to discount things like maternity absences, disability-related absences, and remember also that you should always preferably allow employees to see their own scores and allow them to challenge or question them. I don't know if we want to look at some of the other questions coming in, or how they apply.
If you perhaps take one of those questions, and I just thought it's also worth mentioning, going back to that first question, that the reason that last in first out criteria isn't generally used anymore as a starting point, at least, is because it can give rise to both indirect age discrimination claims and sex discrimination claims, because younger employees are less likely to have a long service history. And it's also been sort of established in case law that females are more likely to change jobs and have fewer years service. So there are potential issues with sort of going with a last in first out approach as opposed to the sort of skills assessment and criteria and the sort of marking that Meredith's been suggesting, is the right way to go for employers. If we go to one of the questions, did you want to take one of those, Meredith?
I mean, the one about pregnancy. Pregnant people are in a special category, actually, because there's a regulation 10 of the maternity and paternity leave regulations gives those in a protected category, or in the protected period, I should say, first dibs on any suitable alternative positions. So they can actually be in a preferential position.
That's obviously if there are other positions available,
yeah.
And open for candidates. I think that the question to sort of widen it out was, someone has 3 branches, there's no work and would like to make redundant or lay off without pay. I mean, I think, and one of the staff just fell pregnant, but you don't treat pregnant people any differently. If there's a wide scale redundancy scenario, they would be included with everyone else. And, you would go through the process with that person the same as anyone else. Sometimes if people don't have 2 years service, you may not always choose to go through the same process. But I think if you're going through one, you should include everyone in that. Layoff obviously is a very specialised category and purely depends on whether you have layoff clauses in your contract of employment or not. And I guess we won't get drawn into layoff in too much detail here, but we can follow up on that afterwards. In terms of alternative employment, Meredith, what obligations does an employer have to find alternative employment for affected employees?
Well, it's problematic if you don't give any consideration to it at all. But the duty on the employer isn't to make every possible effort, but to make reasonable efforts. There was a case where an employer was criticised for not making energetic efforts, but that was found not to be sound, actually. In that case, a senior manager complained because he hadn't been considered for a menial role within the company, and that was found not to be necessary. So it wouldn't be unlawful to discount low-paid roles, for example, and decide they're not suitable for a senior employee. But of course, each case depends on its own facts there. You won't be necessarily expected to look through an entire group of companies or look at legally independent companies for work. And there's this question of what is an associated employer there. But there is a case where an employer was criticised for not putting pressure on a holding company, or rather a parent company, which had significant influence over other companies within its group structure. So that is something that tribunals will consider, the degree of control that one company has over its other companies in the group. And another interesting point which comes up in that context is who should vacant opportunities be offered to first when allocating vacancies between potentially redundant employees? Should you open up to the whole workforce and get the best person for the job? Should you open it up to external candidates? The prevailing position on that is that in the first instance, the employer should limit applications to those who are affected by the redundancy where possible, and make appointments from the pool of candidates before opening it up to the entire workforce. But there is an interesting case here, which I think gave heart to employers at the time, and that was a case against the Welsh Rugby Union, where the elite coach manager and the community coach manager roles were disappearing, and Welsh Rugby Union were creating a new senior role with strategic responsibility for coaching. In that case, both the affected incumbents were up for the new job, but they also involved an external candidate. So that's an example there where it was not found to be unfair to involve someone not from the employer's organisation. But really, each case will go on its own facts. And the lesson in all of this is that tribunals do give employers quite broad discretion. And that goes to actually one of the questions, Angie, that we've had at the top of the chat. No, sorry, that's a new one. Can an organisation that is in financial difficulty look at salary savings? in terms of the broad discretion that an employer has, of say 5%, and ask all parts of the business to look at roles they plan to make redundant, business looks objectively at the roles that the organisation can do without and start to consult with these individuals. Financial difficulties led to commercial decisions to diminish work. Is this a lawful reason for redundancy? I mean, what do we think to that?
I think absolutely it is, and it's also a crossover to the restructure point as well, looking at the structure and saying, right, what roles can we possibly manage without? And you get rid of those roles. There may well also be reduced work coming in, but the process is the same either way. You look at the old structure, you look at the new structure, you consult with the roles that don't any longer appear on the new structure, and that is a legitimate reason for a redundancy / restructure. And you go through the motions, and it should, all be fine. And one of the other questions that came through is, in the current times, is it possible to conduct individual redundancy remotely, or with easing up restrictions, should we consider face-to-face? Certainly, I don't see any reason why these meetings, there's no requirement for them to be face-to-face. The requirement is for engaging and meaningful consultation, and there's no reason that can't take place either through a Zoom meeting or even a telephone call. Historically, it's always been the case. If you've got someone off sick or remote, if you have got, say, someone on maternity leave and you've had to consult with them, that will very often be done by telephone anyway. So there's absolutely no reason that you need to wait for face-to-face meetings to be possible again to start any of this. I think is the answer to that. And so thank you, Meredith, for going through all of those points with regards to individual consultation, and all of those points about, that it's fairly flexible with individual consultation. It's not prescribed by statute. And that's fine where you're looking at fewer than 20 redundancies in a period of 90 days. But Jonathan is going to look at the situation where we're talking about more than 20 people, and where collective consultation obligations start to come into play. So exactly when, Jonathan, do the collective consultation obligations kick in?
Okay, we've lost your sound, Jonathan.
Jonathan, turn your mic on.
Sorry about that, folks. So this applies with large-scale redundancies, and as you say, if there are 20 or more employees involved, and there's a proposal to dismiss them within a period of 90 days or less, that's when it's going to kick in. It's also important to remember that there's the obligation to notify the Secretary of State, the BEIS, using the particular form for that. And it should be remembered that the sanctions for failing to comply with this are pretty draconian, and the employees don't need qualifying service for it. They can be awarded each individually up to 90 days pay. And the fine for not notifying the Secretary of State is now unlimited. It used to be capped at £5,000, but these days it's not.
And what does the word proposing mean in this context when you're proposing to make more than 20 people redundant in a 90-day period?
Well, case law suggests that this kicks in when you lay before somebody else something which you wish to be done. There's a bit of controversy around this because the European law used the term contemplated, but I think the key thing you have to remember is that you need to be able to consult. So that means that those who are being spoken to should be able to influence the decision. Now, the Leicester Council came unstuck with this because they decided to introduce changes to terms and conditions by dismissing and re-engaging employees, but this was made after a council decision occurred. And although there was discussion with the union rightly, in legal terms anyway, were able to argue later it wasn't genuine consultation, because the decision was made at council level, and so they were just talking about something that they couldn't affect.
And what about the scenario where voluntary redundancies are proposed or requested, would that potentially have the effect of bringing the numbers down below the threshold?
Well, the issue is, how many people do you propose to dismiss as redundant? And by its nature, when you ask for volunteers at that stage, you're not going to know that people are going to accept. And there was a case called Voluntary Transport and General Workers Union, where the employer did come unstuck. There were 20 redundancies there, a nice neat number. They asked for volunteers. 3 people came forward. 17 were then selected for redundancy and went through that process. But it was found that it was within the collective consultation provisions, and so that they should have consulted with the union.
And potentially 20 awards against them. They wish they'd kept it to 19.
I mean, I should say that if you're in a situation where you were just generally offering volunteers, it wasn't part of a proposal that had crystallized as yet, then that would be okay. But in most cases, the volunteers are going to be included.
Yeah. And just before I ask you the next question, one of the questions we've had is, would you be breaking furlough rules to engage in consultation with staff about redundancy proposals? And I think we've had a lot of debate in the employment lawyers world about this, but I think it's clear that no, you won't be breaking furlough rules to have consultation during furlough leave, and even have people on notice during furlough leave. And
I think that's right. I mean, it's they're not performing a service for the employer or making
no.
the employer.
And the ACAS guidance actually sort of alludes to the fact that it's envisaged that people might be consulted, etc., while on furlough leave. And so picking up with the collective, I mean, it's another quirk of the rules, as you said earlier, that even people who don't have 2 years service, whilst they wouldn't be entitled to redundancy pay or anything like that, and so can sometimes be forgotten in terms of consultation, they would still be included in the numbers for the purposes of working out whether 20 redundancies have been proposed in a certain period. When you were talking earlier about the definition of redundancy, does the same definition apply here for collective as for individual?
Well, I suppose this is the point in the talk where I have to say, forget what I said earlier, because the answer is actually no. In the particular piece of legislation, section 195 of the Trade Union and Labour Relations Consolidation Act, it talks about a dismissal which is the individual concern, or a number of reasons, all of which are not related to the individual. So if an employer proposes to change terms and conditions through terminating and re-engaging employees, there will be an obligation to consult. Why is this? Because the dismissal would not be connected with the individual employee. So that's enough to be in the definition, even though it might not be for redundancy pay purposes. Indeed, there's a European court decision which suggested that if there's a unilateral change to essential elements of an employee's employment for reasons not connected to his work, and there is a substantial detriment, in that case, there will be an obligation to consult also. Just an example in practice how these things could come up. There was a company in the Kent Tourist Board had an office with 26 people and decided to move the office to another location. They didn't have mobility clauses in their contracts. 26 people involved, 14 were dismissed in the end, and the other 12 went to the other side. Now, in that case, it was found that they should have had collective consultation, because without a mobility clause, it was actually a redundancy situation. They took into account the whole 26, even those who remained in employment. And you can see that, you know, in planning terms, the financial implications of this can be very significant. 26 times 90 days pay was probably not in the original plans of those when they put in place the redundancy.
And you've mentioned that the obligation kicks in if 20 or more are to be made redundant in a 90-day period. What happens if the redundancies are staggered over a period of time?
Well, the way that the 90-day period works is it's looked at as a rolling period. So yes, it is certainly possible that you could split them up as long as the dismissals took effect within entirely different rolling periods. But you can see that actually does mean that the process could be pretty long, and so the savings may not be as great doing that. There is an exception, which is the situation where, say, you've started the 90-day period and then something happens in the business such that a new redundancy program has to come about, and say there's another batch. That wouldn't have to be accumulated with the first batch as long as it's genuinely a separate one. But employers do have to be a bit careful about trying to get around the legislation just by splitting people up into batches. It would have to be genuinely separate.
And obviously everyone's aim is to get around the legislation. So one way that employers historically have done this is to try to make places different establishments for the purpose of the test. So legally, what is an establishment? Well,
and the big piece of litigation around this was the case involving Woolworths. If you remember, when Woolworths went insolvent, and the dispute there legally was about whether every Woolworth employee should be counted as part of the same establishment, or whether you could split it down to the separate stores. It went all the way up to the European Court, and they came back on the facts of this particular case saying that it was only stores with 20 or more in each one that could be treated as the establishment. So it was split up, and the geographic test is often used. Having said that, that is not the precise legal position which is set out in European law, which says that you have to look at whether there's a distinct entity, whether it's got a certain degree of permanence and stability to which employees are assigned, and which has a workforce, technical means, and certain organizational structure to allow it to do so. It doesn't have to have a completely autonomous financial, administrative, or technical structure, but if it's got the technical means and organizational structure to be considered separate. So it's quite a technical test and would have to be applied to the particular facts of the circumstance.
Yeah. And who does I think it's fair to say on all of those cases, they can't always be easily reconciled, and there are some sort of decisions that don't sit quite nicely with other decisions. As always, the courts will often find what they want to find and find a way of finding it. Who does the consultation have to be with? Because this is another sort of pain for employers, especially ones that don't have trade unions or employee reps set up. Who does the consultation have to be with in collective consultation?
Well, something to remember first of all is that you've got to think about not just the employees who are going to be made redundant or might be made redundant. It's also those who are affected by the redundancies or affected by the measures taken as a result. So if after you reduce numbers, you have to reorganize the work or something like that, you would need to consider those people, and those people would have the right to make claims, even if they're outside the group of whatever number. Then you've got to decide who it is you're going to do the consultation with. If there's a recognized union in place, then it will be with the recognized union. If there isn't, then directly elected representatives for this particular purpose will be put in place. Sometimes employers will have some sort of body in place, and so if it's a standing body of elected or appointed representatives, not specifically for this purpose, but who do represent the group involved, then that can be used also. But you just have to be careful to make sure that they genuinely represent all of the categories of affected employees.
And is there a set process that employers have to follow to get representatives elected?
There isn't a set process. There is some flexibility. There are certain principles that have to be followed, and I'll highlight just a couple of those principles. First of all, well, the employer can choose how many representatives. The employer can also choose what categories they are going to represent, as long as you don't have to split it down into sort of dozens of micro categories. So you can have representatives who represent different types of people as well, as long as everybody has got a representative. And all of the affected employees will have to be entitled to vote. And of course, this is an area where you might get problems for the employer because of the risk that, for example, you miss out with people maternity leave, annual leave, people on sick leave, people on furlough, of course. All of these have to be included. And of course, you know, we've been talking about 30-day and 45-day consultation periods, but you've got to remember there's all this part has to be considered as well, you know, before you even get to the stage where you start consultation. So it does make the process, you know, even longer and more expensive for employers.
And once they've got everything in place and they've got their reps lined up to consult with, obviously, first thing, send the HR1 form to the Secretary of State, because that's what you need to do. Get that form filed. But then what has to be done?
Well, there are certain pieces of information that have to be supplied to the representatives in writing, and it's a prescribed list which has to include the reasons for proposed dismissal, the number and descriptions of the employees it's proposed to dismiss, the total number of employees in the categories, the proposed method of selecting, the proposed method of carrying out the dismissals, the proposed method of calculating any redundancy payments, suitable information about the use of agency workers as well. That's an obligation which was introduced just a few years ago, so a more recent one. And then once that information has been given in writing to the representatives, that kicks off your period of time, your 30 days or your 45 days. And then in the consultation, which will then ensue, you must include ways of avoiding dismissals, discussion about reducing the numbers of employees to dismiss, and how to mitigate the consequences of dismissal.
And it's worth saying as well that, as well as all of the consultation with the employee reps, you would still expect to have an individual meeting with the yes, individuals who are at risk at the end of the day, as well as the sort of representative body in the initial stages. Are there any exceptions or defences to failure to carry out? If an employer just says, I haven't got time, and I've certainly had some employers do this at the start, certainly before the furlough scheme was introduced, just said, we haven't got time to consult for 30 or 45 days with people, we just need to do it now. And, you know, on very dangerous ground. So what are the chances of sort of successfully putting a defence? What are the defences available?
Well, there is a defence which I think is relevant in the COVID crisis, which is a special circumstance in which it's not reasonably practicable to comply with the legislation. Having said that, it's not a complete defence, because it also says that all steps are reasonably practicable to comply. So you've got to do as much as you can, not ignore the legislation completely for it to kick in. I think we will see some litigation about this, and it will be interesting to see the parameters, because it's not a defence that's been used particularly often in the past, but I think the present circumstances particularly do point to it. One other thing to say that's important is that when assessing compensation, the tribunal will also look at, they won't automatically award 90 days pay per employee. It's what's reasonably practicable. So anything you can do to comply, any consultation, even if it's shorter than it should be, is always going to go in your favour. in this situation.
Yeah. Well, thank you for that whistle-stop tour through collective consultation. I think we realised earlier in the week when we looked at how much we all had to say that we'd be here for hours if we said everything, and so we have had to condense everything quite a bit to get through the basics. We've got 5 minutes left, and we have had some questions come in, so let's try to answer some of those. So we have a question: if you issue final notice to someone on furlough, should their notice pay in lieu of notice be paid on their normal full-time pay? And then there's another question also on notice about, can an employer reclaim notice pay through the job retention scheme if on furlough? And I think it's fair to say that the whole question of notice pay and what someone should be paid as notice pay is extremely complex, and that is because there's various factors involved. And it will depend on someone's length of notice versus what statute would give them as a minimum, and also what the terms of their furlough say, and also whether they work regular hours or whether they don't work regular hours, whether they have regular pay or not. I think the overwhelming feeling is that there are scenarios, and you really would have to look at every scenario. There's just no blanket answer to this question. But the feeling is that the employment tribunals, if people end up being paid furlough pay instead of their normal pay for a notice period, the tribunals will bend over backwards to try and say that that shouldn't have happened, and that for whatever the notice period was, they should have been paid their normal pay. And so there's a risk, I feel, and I think Meredith and Jonathan would agree, there will be a risk if if someone's on furlough and they're going to be on furlough for the next month and they've got a month's notice period, if you pay them 80% of whatever their furlough pay is instead of their normal pay for that notice period, there will be a risk that they'll make a claim and that it may be successful. So if at all possible, that's not to say, so you can have the notice during the furlough and reclaim, so effectively you're getting some subsidised notice period, but that top up I think is going to be an area for dispute. There are certainly legal ways that we've seen in certain scenarios where you could say, well, actually, yeah, their normal pay now is the furlough pay, but that's not going to be the case all of the time. And the other thing is, because one of the questions mentioned pile-on, so pay in lieu of notice, I think in any scenario where you've got pile-on, you can't reclaim that under the job retention scheme because they're not still employed at that for that period. So pile-on will be a separate question as well. But if you give notice and they remain employed throughout the period of that notice, albeit on furlough, then you can still get the furlough grant to subsidise whatever the notice is. But what you're actually supposed to pay in terms of notice comes down to a number of different factors. I don't know if I've explained that well. Do either of you have anything to chip in on that?
No.
Meredith, you're turned off. I can't hear you.
I've had my audio turned off the whole time there. No, I wouldn't add anything. I'd simply concur. Some of the learned judges in the House of Lords used to say.
And then we had another question, maybe one of you can quickly deal with this before we finish, that would it be lawful to ask a high earner to accept a reduced salary when others won't?
Well, I would say yes to that, provided you've got legitimate reason for it. I mean, it's quite common for certainly senior tier to take a pay cut before everybody else. It might be safer to apply a concomitant pay reduction across the board, though, to avoid any ill feeling. But I can't see it being unlawful, provided you've got a good reason for it. That would be my gut feeling. Yeah.
And I think one final question, if we can try and get all of them done, this would do everyone's. Please, what are your thoughts on placing senior managers at risk for 30 days and also their direct line, and ask them to complete a selection process at the same time within the 30 days they are also at risk. I'm guessing we're talking about collective here because they're specifying a 30-day period. And I guess completing the actual selection process, etc., during that 30-day period. Is there any reason why everyone can't be at risk and then the scoring and everything gets done?
Well, the important thing would be that there is consultation on the scoring process itself. On this, we're assuming for a moment that there is collective consultation in this case. Then, as long as there has been consultation on the selection criteria, it wouldn't necessarily prevent you from starting a process. But what you don't want to do is be in a situation where consultation hasn't finished and you're jumping the gun in terms of something which would affect how those individuals are impacted. Mm-hmm. So, I would say don't start it too early, and make sure you've covered off everything in the consultation which would impact the situation for those particular people.
So thank you to everyone for engaging and asking questions. Hopefully you found that helpful. If you have any further questions on the subject of today's webinar, or indeed any other employment law matters, please do get in touch with us. I mean, obviously, this is what we do day in, day out. We can draft your redundancy letters. We can talk you through your specific process. We can look at your selection pools and advise you of any risks that you face. And, that investment in getting the right advice up front really can save so much money and costly problems down the line. So all of our contact details can be found on our website, which is www.thomasmansfield.com. You can get in touch with any of us directly through our website. And our next webinar, which is in July, is going to be on contracts, policies and workplace procedures, because we do imagine that in the light of the scenarios that this COVID pandemic has thrown up, there are going to be some changes that employers might think, actually, if we'd had this policy in place, or if we'd had this in place, it would have helped us. So we do think that that's probably a topical thing. But if you have any subjects that you think I would really like to see this covered, please do drop us a line, let us know, because we're just imagining what employers are wanting out there, and it would be great to have some feedback to know exactly what you'd like to see. So bye for now. Stay safe, everyone, and thank you for tuning in to the webinar.
Thank you.
Thanks very much.
Thank you.